On the subject of admitting privileges, Senator Hager,
Yes, ma'am.
are you aware of any other Texas laws that require other outpatient procedures to be performed by a doctor who has admitting privileges at a nearby hospital?
I know that doctors have obviously a standard of care, and I do not have a list of admitting privileges in front of me, but I do believe it is important for abortion doctors to have admitting privileges because I think it raises a standard of care and it shows that these doctors, there can be severe complications, and I think it's important that they have admitting privileges. And as we heard in testimony, individuals that may have severe complications, those complications occur at the hospital. So part of the reporting issues that was asked about by Senator West and asked about in committee, we heard an enormous amount of testimony that said the doctors in the hospitals, they said they didn't have a box to check to put on the website. So all of those, in those instances, they're per se not reported. And so the point being is, I believe that abortion doctors should be required to have those privileges, regardless of whether other types of physicians are required to or not.
And you are aware that there's a strong disagreement about that part of the bill?
You and I have talked about that. Yes, ma'am.
Thank you. And Senator Hager, we who serve on the Senate Health and Human Services Committee were so impressed that you stayed throughout the hearing. And we thank you for that because we were there a long time and you stayed there with us. And that doesn't happen very often. We appreciate that. You were present, were you not, during the testimony of Ellen Cooper from the Department of State Health Services?
She testified several times, if I recall correctly, as well as one of the other ladies from the Health and Human Services as well. Yes, ma'am.
I asked her several questions, and I know that you were present when I asked these particular questions. But I asked Ms. Cooper, who is the manager of the Health Facility Licensing Department of the Health and Human Service of the Health Agency, and who is a registered nurse with an advanced degree, and we did establish that she was qualified to answer these questions. One of the questions was, based on your inspections of abortion clinics, are there any findings that would indicate there is a problem with the safety of the health care delivered in those facilities? And the answer was no. So if the answer is no, why do we need this bill?
I think that several of it, number one, she provided testimony and she also talked about the incident rate that was asked earlier. And when you talk about those specific incident rates, they don't have the data because the data that I think Senator West was referring showed that there's not that many incidences, but the testimony provided that there are at the hospitals as well as that data is coming forward. I believe this is important to raise the standard of care to make sure that the number of incidences are less. ASCs, individuals, kids going in for tubes in their ears, cataracts, those are basic procedures and those are required at ASC standards, and I believe that the complications that come with an abortion also should be at the ASC standard for the higher care.
Thank you. I also asked her, how often does the agency inspect abortion clinics and are the inspections announced? And much to our surprise, we realized that licensed abortion facilities are inspected every year, every single year, and that the inspections are not announced. But ambulatory surgical centers are inspected every 3 to 6 years. So don't you believe that that would be a lower standard of care?
I do not, and I also remember that Dr. Matthew Ronberg, who was one of the expert witnesses opposed to the legislation, he said that he thought that annual inspections were overzealous and every 3 years were adequate inspections.
Thank you. I also asked her if she thought that ambulatory surgical centers were safer facilities than abortion clinics. Do you believe that they are, Senator?
Do I believe that abortion clinics are as safe as...
That ambulatory surgical centers are safer?
I believe they're safer, and I remember she had given some response. I don't remember, you probably remember exact response because you're going to quote it to me.
No, I want to know your response.
No, well, my response is I do believe that ASCs, they're held to a higher standard. They have better facilities, and I think that those facilities are the standards that we need to have in the state of Texas. And I do not believe that it's the higher standards and the higher quality of care, not necessarily yearly or every 3 or 4 year inspections. I don't think it's the routine of the inspection, but it's the standard of care at those facilities.
Thank you. I also asked several related questions. One was, to your knowledge, is there any health-related reason to require medical abortions to be performed at an ambulatory surgical center? A second one was, do surgical abortions require an incision? And the third one was, if not, is there any health-related reason to require surgical abortions be performed in an ambulatory surgical center? And finally, I asked her, would a patient be safer receiving a surgical abortion at an ambulatory surgical center than at a licensed abortion facilities? And you remember her response, I'm sure.
Now, I remembered that, if I remembered, she said that she didn't see any reason they were safer at one or the other, if I remember her exact words.
Well, my impression was that there really was no reason to change these requirements.
But I also heard from several other witnesses, not just the state resource, who obviously it is their job to make sure that these facilities are safe, and if they answer to the otherwise, then that means that they're not doing their job. So I think they have an incentive to say one way.
One of the things that surprised me during the hearing, Senator Hager, is that we asked so many questions that obviously the witness to whom we directed them could not answer our questions satisfactorily. And my question is, why weren't additional witnesses brought in to answer those questions, such as, for example, the ones that I just raised or the one specifically about fetal pain, because there was such a controversy?
Well, I'm not sure. I think it's interesting if you're asking about the fetal pain portion, because that's been the only portion that you've supported.
Not the fetal pain. I supported the 20 months, the 5-month unborn child not being
regardless of whether it's pain or any other reason.
That's right.
Okay, I'm sorry.
I mean,
I misstated. I'm
if
sorry.
you were to prove to me that an unborn child felt pain at 20 weeks, or if you were to prove the opposite, I would still support the prohibition of an unborn child.
Regardless of the reason. Okay,
Exactly.
I understand. Yes, ma'am, I'm sorry.
But because, and what I don't understand, Senator Hager, is why you haven't shared a picture of what an unborn child looks like.
Well, because I thought you would.
Well, it's just such a dramatic picture. You know, and 20 weeks just doesn't sound as powerful as 5 months.
It does.
5 months. And I think that people should know what an unborn child looks like at 5 months.
And I appreciate you showing that. Thank you for doing that.
And I really believe that the fetal pain is another issue. I
Okay.
happen to feel there isn't substantial evidence, but that doesn't impact my feeling
Okay.
about that particular issue.
Thank you.
Thank you. Turning to the fiscal note, Senator
Yes, ma'am.
Hager. On page 2 of the fiscal note.
Of the
The fiscal note. I'll let you get to it.
Okay, go ahead. I'm looking for it.
There is a section titled Local Government Impact.
Uh-huh.
I'm reading from it. The bill would create a fine-only Class A misdemeanor offense, punishable by a fine not to exceed $4,000. Costs associated with enforcement, prosecution, and confinement could likely be absorbed with existing resources. Revenue from fines imposed and collected is not anticipated to have a significant fiscal impact. My question is, who is subject to these fines? Under your bill, specifically, who would be subject to this Class A misdemeanor?
Well, there's a couple of situations in whereby the doctors would be subject to that fine, that up to $4,000 fine.
And could you share those with us, please?
Share with you
Who would be subject and under what circumstances?
the doctor. So in other words, the doctor, if they did not perform, if I recall, I'll try to find the exact line item in here. Because say, for example, on page 2, line 219 and 220, the physician who violates subsection A commits an offense. The offense under this section, and again, that was the physician, is a Class A misdemeanor punishable by a fine of only up to and not to exceed $4,000. That's the physician, and that is for admitting privileges to a hospital. That's number 1. And then I'll find the exact section, if I recall, in here is also for the it's also trying to find the exact language, but the point is several times in here the fines are to the doctor, and the doctor is who has the fine. And then obviously they can appeal that to the medical board.
Thank you. Senator Hager, you and I also discussed, and I provided last session some amendments to the bill. I didn't present them in the hearing simply because I knew we would vote on them today, and I knew what the outcome would be yesterday. But my amendment would replace the word substantial with the word some before medical evidence. Do you intend to entertain my motion to amend the bill accordingly?
Well, obviously, I will see the amendment if you offer it, but I disagree with you, as you and I have talked numerous times, as to whether there is your word some or my word substantial, and I would not accept an amendment to make that change.
We also discussed the exceptions that would allow abortions after 5 months. And my concern was that you did not include a woman's psychological condition.
Correct.
Could you explain to me why it is that you would not accept such an amendment to include the words that a woman's psychological condition could be considered for purposes of an exception if it existed prior to her pregnancy?
I think that that's, again, if there is this bill, if there is some type of physical harm, severe, or some type of harm to the woman, the lady, that this bill provides an exception. And it also makes very clear that if someone comes in and says, I'm going to do harm to myself, that is not an exception. But if there is some physical harm to her or something specific or life-threatening, and I think that your amendment is not as workable, for better words, and not something that I think really fits into the legislation because of the way it's worded, Senator.
Okay, thank you. We also discussed changing the term severe irreversible brain impairment and substituting it with severe fetal abnormality. And that was to ensure that exceptions in favor of an abortion were not made for unborn children with mental disabilities such as Down syndrome. Now, you did accept my suggestion in several places, but not in Section 6 of this bill. And could you explain to me why you accepted it elsewhere, but not in Section 6?
And point out specifically in section,
Page 7, lines 13 to 14, Section 6 of the bill.
well, that section of the bill, we were not adding anything in page 6 and 7. Are you talking about far as where it reads the occupation code?
Section 6 of the bill in Section 164.052A18, Occupations Code.
And that's reading where the physician or the applicant of a license to practice medicine commits a prohibited practice if that person, and this is a list of offenses that person commits.
I might have the wrong reference in my notes here, but nevertheless, it does change that term, severe irreversible brain impairment, to substitute severe fetal abnormality. And I'll double check the...
That section of the bill is a list of situations to where a physician or an applicant is prohibited for the practice of medicine, and the only thing in there we were adding in was on page 7, 30 through 32, which is inducing or attempting to, as in prior to the 20-week period outside the exceptions. But I would say that I've gladly made that change, and I think that it applies throughout the bill, Senator, with all respect. And the reason is because that severe fetal anomaly, I do not believe it applies in a situation if a child has any mental disabilities, because as you and I have talked about, I would be appalled for that type of a situation. And the language and the definition is to the child not being able to survive outside the womb. So it's a survivability and not necessarily a type of condition, whether it's mental or physical.
All right. I do have another amendment that I'll propose at the right time, and that is
Okay.
to strike everything in the bill except the reference to prohibiting an abortion at 20 weeks. And will you entertain that motion?
You've asked me 3 times, and no, ma'am.
Thank you, Senator. Thank
appreciate
you
it.
for your courtesy in answering my questions.
Anytime, Senator Zaffirini.
you.
Thank you.